18th of May 2022, video 45H, wind farms and pylons. This video is for a specialist purpose and a specialised group of people. There is or are in Ireland communities all over the place threatened with pylons and wind farm planning applications. And I've been there, and unfortunately my one here in Kingscourt was one of the first. But I'm learning as I'm going along, and I'd like to share my information with other groups. If the French to Wexford interconnector goes ahead, all of Ireland will be covered in wind farms. The idea is that France will protect its own country and destroy Ireland. That's what our government has in store for us. Whether it's fair or not is not the point. It's going to affect communities all over the country as the coming years unfold, unless we can stop it. My case is they don't work. They're useless. We have a situation in Germany where they're panicking. They have to break EU law and they have to get special bank accounts in Russian banks for energy, for electricity and other things. And they have more windmills than anyone else, and they're doing nothing. Here in Ireland, we have wind farms and solar farms equal to average daily demand, and still we're burning fossil fuel, and we have a coal-fired power plant running full throttle because these things do very, very little. They can't be used on their own. They're only a sideline to fossil fuel or nuclear generation. Now, I'm speaking fairly close to the camera because a few commentators on earlier videos have said they get it hard to hear me, and I'm sorry about that. All I can do is my best, and you just have to try and make the best of it. But this could be helpful. Now, I am not a lawyer. I'm doing this to protect my environment and help people, and I can't be accountable for the advice I give and how it's used. But this could be a help and could be a guide to you. Now, the first thing to know, and this is 45H, if you're not interested in this, please turn it off. Go on and do something else. Don't waste time. My video channel is for several different topics, and you can't expect to find everything you want. I mean, if you buy the paper, you might never look at the horse racing. You might just look at the football. You mightn't look at sport at all. You might look at some other thing or some incident. And this is the same. There'll be parts of my channel which apply to various people. But as Frankie Byrne used to say on the Jacobs program long ago on the radio, the problems I mentioned mightn't be yours now, but they could be someday. She was an agony aunt. Now, this is the situation where a wind farm is proposed at the moment. They're getting unlimited amounts of cash. It's mostly printed. It's given by the European Investment Bank. It's unlimited. It's any amount. Money is no obstacle. Whether that can last or whether it's signed of a Ponzi scheme, I cannot tell you. All I can tell you is that they're not making money. Any of the accounts I checked are making nothing. And you know, with the Derrybrine wind farm over in Galway, the ESB had to pump 10.1 million euros into that in 2018, and they're all the same. I don't know who's backing them. It could be a Ponzi scheme. We don't know. That's not the point. You want to stop it when it comes your way. And the planning authority in Ireland is the Planning and Development Act. That's the law. The Planning and Development Act 2000. And that's been upgraded, and there was a previous act. They don't usually scrap the whole act and make a new act. They add to it and amend it. And so online, if you're using it, you get the consolidated version, or the Law Reform Commission version, which has the changes to it there. Now, it's unbelievable heavy stuff. It's unbelievable. I doubt if anyone fully knows the act. Now, but that's a development. Now, under that Planning and Development Act, you can have retention development for unauthorised developments. You can have exempted development for putting areas up on houses and different things and building walls on back of your house and things like that. They're all specified in the Act in a big long schedule. So we'll not go there, but what is important is that the Planning and Development Act is the vehicle in Ireland that launches the European law on this, okay? That's all you really need to know. It's the vehicle. It's the way the application is made. It has to be made under the Planning and Development Act. Now, in the Treaty of the Functioning of the European Union, one of the things was guaranteed was certain rights, and one of those rights was the right to a proper, clean environment for your well-being. That's written there in the when we voted on the treaties and the Lisbon Treaty. And now also the Lisbon Treaty reiterated this. Up to date, it hasn't been worth the paper it is written on. Totally ignored, and particularly in Ireland. But that doesn't mean it's not relevant to your case. It is very relevant. It's the only actual hope there is. Now remember, it's the EU is pushing this renewables and trying to finance it. Now there's the Aarhus Convention. After the fall of all the communist states and the destruction they wrought on the environment, the world communities and the United Nations tried to get some kind of an agreement that there'd be an assessment process before they'd go doing destruction. And the Aarhus Convention is that, and it is law in Ireland now. Took Ireland with the Green Party in power, was one of the last countries to sign it. So this is all fake. You know that the Green cause is all fakery, of course. You know that it's there to get them votes from naive, stupid people all over the country who think they have something to save the planet. So they're not really. That's not the case at all. Now, what the Aarhus Convention, and there's a compliance committee in relation to it. I'm not suggesting you use it here. What the Aarhus Convention does is it provided that agreement, and it should have compelled the governments to work on it, but they didn't want it. But the Dublin engineer, Pat Swords, he's a Dublin engineer, he's taking a case that starts 10 years, and he's upgraded it, and I won't quote him because I meant to interview him, and we probably will try and interview him at some stage. But he's taken a case, and at the moment it's the European Investment Bank, about them giving all this money without doing the proper assessment. Pat also took a case in the courts in Dublin against the lockdowns for the COVID, and when he brought the case up, he demanded to see the documentation that's required. The government pulled the whole lockdowns off. That's only a while back. So he's effective that way. But I don't want to quote him because he's very particular about how you quote him, and I want to make it clear I'd rather interview him than anything else. But he's working on that, and he's getting grudging progress. They're yielding a little bit, but they're doing it very, very grudgingly. The Irish government does not like, and the EU government, any ordinary Joe Soap tackling them. Okay. Now, on foot of the Aarhus Convention is the Strategic Environmental Assessment Directive. And a gentleman at a big conference I was at one time told me that's soft law and it's useless. In other words, that the EU directives are useless. They're not useless, it's just that they're very hard to get a way in and a way of attacking them. So if you look up the Strategic Environmental Assessment, you get it there online, right? And look, Article 3.2, you'll see that certain industries as automatically have to be assessed if it's a plan or program. Now there's a difference in planning permission, which is for development. There's a difference in a project which is under the EIA directive. That's the local wind farm, the local pylons, the local quarry, the local whatever. That's the project. But the plan or program is a public government plan or program. So if government brought out a big plan for forestry now in the next while, they should submit that to the SCA process, and it should be assessed by qualified people. And if they brought out one on energy or what else it says, in agriculture, fisheries, forestry, tourism, town and country planning, and I think river basin management is there as well. There's a few other ones there, which set the framework for the EIA, for the projects under it. So essentially now, and I know this is getting heavy weather, and this is why I don't want people looking at it unless they have to. I had to study it, but if you don't know it, but it'd be good if people would. The SCA directive is for the overarching plan or program. The overarching plan or program. and then the EIA is under that, and it states in the directive, and you'll get it there, it's the number of it is, and I better write it down here and just pause. No, I just paused there to give you the number. It's 20142 EC. You just Google that SEA directive and get the proper one from the actual proper one with the whole thing written out in plain ordinary writing. All those directives have a preamble which is not binding. They then have the legal bit, what you have to do, and then they have the annexes, what it applies to. It's only the middle bit and the annexes that are binding. Okay, so now that's the directive. So the obvious question was, why was the National Renewable Energy Action Plan of 2010 not subjected to the proper assessment? And Mr. Swords tried that on his own, with no help. And he got a bit of progress, but the judge wasn't inclined to hear it. And I maintain there is no course for any judges. Judges are expected to learn this on their own, and some of them are quite okay on it, and some of them aren't. And it's the look of the draw whom you get. Now, but between the jigs and the reels, I took a case against the North-South Interconnector in 2016, demanding that it couldn't get permission until the proper SEA, Strategic Environmental Assessment, was carried out. And my case was that it was a bit like if the Gardaí, the police, went into a pub and found a whole lot of people drinking there after hours. And it turned out the pub had no licence at all. Well then, how can you prosecute people for being on a pub that's not licensed or doesn't exist? Get my point? It's the same as taxi regulations. If you get a lift in a taxi, if it's not a registered taxi at all, and he's not a registered driver, the driver, really, like, the regulations doesn't apply. The summons for him is for operating as a taxi driver without having the requisite license paperwork. But I took that and I fought it up there for 2 days, and the response of the Airgrid was to do what they liked, and Burplanola was said they'd sanction more or less anything that Airgrid wanted. And the judge said that Burplanola had no substantial decision to make, more or less that they couldn't refuse it, after them taking €43,000 in fees. That's another day. I'm not here to whinge about that. That's for another day. Now, so that was one effort. But other than that, it's surprisingly difficult. And another thing about a lay litigant, if you go in on your own without lawyers, you can only go to the Supreme Court. You cannot go to the European Court of Justice without lawyers. And we couldn't get good lawyers, but we were making progress. I think we have a wee bit of line up now. They've taken this on. A few firms have taken it on. Some have been very successful, but not on the SEA directive. I have to speak louder, I think, because my throat's getting dry. So we couldn't get in on it. But all applications for wind farms in Ireland have reference in them in the EIA, in the Environmental Impact Assessment, which is there under Part 10 of the Planning Development Act. It sits on top of the Planning and Development Act and is incorporated into it. So the Planning and Development Act is the vehicle which carries the wider Environmental Impact Assessment. And that includes the need for the project, public participation, the right to people to participate when all options are open and have the decisions taken into account and reasons given for the decision. Okay. So that's the EIA, that's European law. Now, if you take a judicial review on Irish planning law, you can only go as far as the High Court. If it's EU law, you can technically go to the European Court of Justice, but you can't go without legal representation, and that's where we were caught. Now, the 2006 planning or wind energy guidelines were issued in virtually every EU country I know. There might be one or two exceptions, don't quote me, but they're definitely implemented in Ireland, Britain, when it was in the EU, Belgium, Holland, and other countries. Okay, these guidelines set out the guidelines for the distance from residences, the shadow flicker recommendations, what has to be done, what hasn't to be done, and noise, particular noise, decibel readings. And a lot of the things you'd expect for a wind farm are contained therein. But of course, the distance is only 500 metres, and a modern wind turbine can be 150 metres. So that's what's stuck on your door, and that's what they're doing, because if they made it any bigger, there'd be a problem. They wouldn't get enough windmills into the country. Now, I have Rara wind farm here, 520 metres, and it is an absolute nightmare when they're that near you. But we're not here to crib. We're here to win and to defeat this menace. So I think you're with me so far. I hope I'm holding you with me so far. Now, the next thing about it is we couldn't get in. So here about a couple of years ago, 3 years ago, a wind farm almost identical to the Rara wind farm in Kingscourt in Ireland was proposed in Belgium. And the EIA was done all right, and in it they referred to the planning and to the guidelines, a circular, which was issued by a sub-authority in Belgium. Now in Ireland, the wind energy guidelines are issued by the government, by the Department of Energy, I think it is, or Environment, I'm not too sure, but it's issued by a state body. In other countries, and there's nothing wrong with this, sub parts of the country, local governments can do the same. Technically, a county council could do it here, but they don't, because you have the National Wind Energy Guidelines. It doesn't matter who they are. But anyway, they took a case to the local court to say that these wind energy guidelines did not comply with the SCA directive. They were never assessed. There was no opportunity for public consultation. There was no assessment, there was no environmental report, there was absolutely nothing. They were plucked out of the air by some, probably, I'd say a girl, it could be a fella in a pencil skirt or a pinstripe suit, and he thought that looked well, and they were rubber stamped in that in Belgium. They were rubber stamped in Ireland, and that's where it stood. So, funny enough, this group saw something that I have to admit I didn't spot, but I wouldn't have been able to run with it anyway, and I'm aware now I'm on 17 minutes, I'll soon have to stop. They took a case that the guidelines, it's a circular or a booklet or a pamphlet issued by the Belgium local government, was not compliant with the SCA directive, and therefore that the environmental impact assessment was defective because it was not, the guidelines for the setback, the noise and all that stuff has not been assessed under Article 3.2 of the SCA Directive 2001/42/EC. And this was the first time this was done. I had been wondering how you could get it done. We could never get enough money to do it. And we mightn't have thought of the guidelines, but it was a very clever move. How can you use guidelines if they don't comply? Because they are part of the plan or programme. Government brought out the plan or programme for wind energy guidelines, and they were issued under that. Now the case went to the courts in Belgium, and the highest court in Belgium sent it to the European Court of Justice because European law was involved. And the European Court of Justice gave its ruling, and the case is 2419. 2419. Do you see it there? 2419. 2419. Now, to get a case on the European Court of Justice, and there are a lot, you go into the Info Curia. Info Curia. I don't know, can you see it? INFOCURIA, and you'll see case law. And there's a search facility there, and you type in the number 2419 and you press search, and up it comes. Up it comes. Okay. Now, funny enough, and I want to finish with this because I want to come back to it, I'll be coming back again. Funny enough with this particular thing, you can see the inference. If the Court of Justice was to rule these guidelines in the local guidelines were legal, and that they had to quash the planning permission for the wind farms, what happened to existing wind farms built in contravention of it? That was the question they put. So the judgment is not that long actually. I'll just go into it, a quick look at it here because I know time is in the essence, but the judgment is not that long. It's quite easily written. It's written for every language. And it's only about 3 pages. And remember, there's an Advocate General when you go into the European Court, it's all on points of law, whether something applies or doesn't, or whether it applies to the particular thing. And there's an advocate general who gives his opinion or her opinion, and usually they get it right. They advise the court. The court can go against them, but in a lot of cases, it's all done on the paperwork. The advocate general considers it and looks at it and gives his opinion to the court. I have seen nothing wrong with that at all. It's perfectly above board. It's perfectly all right. There might be times, there are times when the court ruled wrong, in my opinion, and that was particularly over the right of Germans took the court on inflation and different things about money. They don't always get it right, but I'm dealing with this matter, and this is the only hope we have, and in this case they did. So the court had to give its ruling, and all you need to do now, before you go, those that are interested, is go into that website and get up case 25/19, 25/19, and read it down, and I'll be dealing with it now again. And this is where I'd hope people will go, because they cannot get all these wind farms up without coming across an odd group with a bit of money. And there could be an odd rich person living there who will invest a bit of money. And they'll be going in on very minor things on the EIA directive and the Planning and Development Act and all that. But the thing is, why not cut the head off the snake altogether? I mean, the overall plan or programme, the National Renewable Energy Action Plan here, that's repeated under a directive by the EU. I think it's 209/28 EU, directing that wind energy, that renewable energy be installed. They left 11 different forms of energy. Ireland went exclusively for wind and solar. They never looked at retrofitting or any of the other great ways there was to try and cut back on emissions and to have the efficient use of energy. And they've done that, as you know well, I know well, money. All the bios and the builders was pushing the government, get this invoked and we'll get money and we'll make money and all this. And it's one of the things driving the Irish economy at the moment. And it's unbelievably destructive. So now that's a long enough video, folks. I'm going to leave it at that. I'm coming back now to the SCA, to the judgment of the European Court, and hopefully we'll be able to get you all up to speed with it. As I say, I'm not a barrister, I'm not a lawyer. I'm just trying to do my best and put you in the right way. I can't be held accountable for my advice, but I can put you in the general way. You might as well know what's in my head. I am, after all, 12 years dealing with this. I have a business degree course obtained in 2003, and I'm a farmer, and I just like to get this across. So it's long enough. We leave it at that now. We'll see you back. You can give me a thumbs up or a thumbs down, and thank you very much.